why don't you come on back with me and we'll talk in the treatment area? Something like that. But use your good judgment. You can certainly be friendly and be interactive as much as possible, but avoid discussing their personal health situation as much as possible. Ways that you can identify a patient, certainly more than your name. So if you have a name, an address, social security number, fingerprints, photograph, names of relatives, name of employer, birth date, telephone, fax numbers, email address, account number, clinic or medical record number, vehicle or other device serial number, driver's license number, date of admissions, date of discharges, things like that. If you can identify who the person is through a myriad of ways, and you have information as it relates to their health, healthcare, or healthcare payments, you must protect this information. There are permitted uses and disclosures of health information. Like we said, you can use it for treatment, payment, and healthcare operations. Healthcare providers can communicate internally and externally with one another to carry out the essential healthcare functions. You can also disclose health information to the individual patient. The opportunity by the patient to agree or object. We must give the patient an opportunity to agree or object to disclosures of information to family members, significant others, advocates, legal representatives. We'll discuss that form. It's a release of information form. And basically what I'm saying here is that the patient can designate on that form who can and who cannot have access to their information. So don't ever assume because you have someone who is married that their spouse is automatically allowed to have information about their health, their health care, or health care payments. Technically, without their restricting us in any of those areas, we would probably divulge those things to the people we think are most obvious. But if a patient does ask you to designate certain people and certain communications, we'll have a form made available to you that you can have them fill out and sign, and that'll be a part of their permanent record. Issues of public policy, medical emergencies, law enforcement purposes, workers' compensation, victims of abuse, neglect, domestic violence, research, judicial, and administrative proceedings, healthcare oversight activities. That is also permitted in certain situations, and we'll give you more detail about that. A limited data set is only for research, public policy disclosure, Department of Health, and healthcare operation purposes. The release of information form, as I said, needs to be filled out by the patient who designates who can have access to their information if they want to stipulate that. That form is required, and it requires the patient's name, for instance, specific name or person or organization to whom the organization is making a request, describes the specific listing of information to be used or disclosed, description of each purpose of the requested use or disclosure, an expiration date of the specific event or condition, patient's signature and date. It must be written in plain language. A copy has to go to the patient. There's several things that are required on that form, but the form is very self-explanatory. So if you have a patient that asks they want to limit someone's access to information and it's authorized to do so, make sure this release of information form is signed and dated by the patient. Now the patient has rights, and these are areas that I want to discuss in a little bit of detail. They have more rights than ever before, so be very aware of these. Hipaa gives individuals the following rights: to receive a written notice of the agency's privacy practices, and his or her rights must receive at the first contact with the healthcare provider at screening or intake. The notice of privacy practices is a document. If you're here at the clinic in San Diego, you're probably going to see those occasionally. We typically have the new patients receive those right when they come in and basically have them sign an acknowledgement that they received it. But if you do see these forms, if, for instance, a patient is coming back for the first time since we enacted our Hipaa policies, you're going to see this notice of privacy practices inside your record. And if you're in the off-site clinics, these will be made available to you as soon as I can get those to you. As of this recording, December 31st, 2003, we have not started the new term, but they will be made available to you very quickly within the first week of this coming term in the winter. So be aware that this notice of privacy practices has to be given to each of your patients. It's our 4 or 5 page document that tells how we are complying to Hipaa basically. And the first time you take them to the treatment table, what you'll do is say, Mr. Jones, I'd like to first give you the notice of our privacy practices. They'll take it from you typically, And then there's a second form. It's an acknowledgement of receipt. This is not an acknowledgement that they agree with our policies. It's not an acknowledgement that they understand the policies. It's simply a signed document by the patient that they received a copy of our Notice of Privacy Practices. You must put this notice in the patient's hands the very first contact you have with them. And then after that, you'll put the copy of the acknowledgement, or excuse me, the original of the acknowledgement in the patient's record where it'll be kept forever until that record's destroyed. Then on the outside of that record, we'll have blue stickers which have an H on them, which stands for Hipaa. So from that time on, every time you pull a record, if you see a blue H on the outside of the record, they have an acknowledgement inside the record that they received their Notice of Privacy Practices. If you don't see the H, you are required to give them the notice, have them sign the acknowledgement before you treat them. I think this is pretty clear, but if you have any questions, you can contact me. At the bottom of the acknowledgement form is a space that if the patient doesn't want to receive the form, you simply sign your name and date at the bottom that they refuse to receive their form. Now, the patient also has a right to request access to their own information. They can inspect and request copies of their medical records, a portion or the entire record. They can inspect the record physically there if they wish to do so, and you have time and you can supervise that. But if they want copies of any portion of their record, there's a form that will be made available to you, and they are in the clinic office here, where they have to request a copy. There's a fee that's related to that copy, and there's a time frame that we have to get them that copy. So they can't simply have it copied the moment they ask for it. It has to be requested in writing, and that request has to be included in their records. They have a right to request corrections of erroneous or incomplete information in their records. And again, if they question something that was documented or said about their condition or anything, they can request in writing that that be evaluated and be amended if possible. There will be a committee that will meet together over that request, and it will be determined whether that should be amended or not. But they can't simply change items in the record, nor can you simply change items in the record. They have a right to request transmittal of communication in an alternate manner or location. For instance, they can stipulate to us if they want to be contacted by fax or mail or email, so forth and so on. The address they want it to go to, the P.O. box, they can give us specifics on that. In the case of medical emergencies, if a person is incapacitated or medical emergencies occurring, the healthcare organization may use or disclose health information without authorization. Allows reporting of any abuse or neglect, child, elder, or domestic violence. If such a disclosure is made, the organization must inform the patient or personal representative. Exception to informing a personal representative can be made if it is believed that the personal representative is responsible for the abuse or neglect. Also, if there is reasonable belief that informing the patient would endanger them or place them at serious risk or harm. It allows post-report sharing and communication. You can disclose to law enforcement without authorization, to locate missing persons, to report a victim of crime, to report a crime on the program premises against a workforce member, crimes during a medical emergency, to alert officials to a death of a person. We may disclose to jail or other correctional institution only while the inmate is in custody. We can disclose with bench subpoenas, court orders, court-ordered warrants, and summons. Now, a business associate and a business associate agreement is what I want to discuss for a moment. A business associate is a person who performs a function or activity on behalf of or provides services to a healthcare provider that involves individually identifiable information. We have people that work with us. We have professional people, for instance, lawyers and bookkeepers. We have cleaning people. We have, for instance, Dr. Linda Harvey Carter, who has TCM formulas, and she gets requests from our clinic via fax, patient's name, requests for certain herbs, and those herbs are filled. They would be considered business associates. So they're actually individuals or organizations that perform a function on behalf of PCOM, and they have access to individually identifiable information. A business associate is not a workforce member, so if you have a faculty or staff or other student here that you're working with, you don't need to have an agreement amongst us, because it's understood that we are going to be working together. And a business associate is another covered entity. Now, the business associate agreement, we must enter into that agreement, and it allows basically access to health information. We must make steps to obtain satisfactory assurance, and this is what this agreement provides, that a business associate will also protect the privacy and security of that information they share or receive that they're given access to. We can cure or terminate the agreement if a violation occurs at any time. Now, we're to require of ourselves reasonable safeguards with regard to privacy and security. We must implement appropriate administrative procedures to protect the privacy of health information. The privacy and security policies, workforce security, computer and building security, privacy training, building security procedures. We must implement physical safeguards to protect the privacy of health information. Access controls, as we said before, password controls for individuals that have access on the computer. Electronic information, we have to have locked files, locked record rooms for hard copy records. All those things are established in our policies and procedures, and we have actually individuals responsible for all those areas. I, as the clinical director, am responsible for the physical security of the records and for having procedures for all of you who are students or faculty or staff. We have our information technology department that is responsible for the computer side of it. We have the building side of it, the security side of it, which we try to maintain limits on access to our building and to records and those kind of things. You shouldn't allow people that you don't recognize inside the clinic area, other than patients, of course. And so knowing who is walking in and out of your clinic and who these individuals are, so when I ask people to wear their lab coats or have their name tags on, it identifies them to me and to anyone else. They're a part of our workforce. So be aware of that. Be alert to that. That protected health information is a very, very serious issue, and we have to all use our due diligence as best we can to protect it. Now, I want to discuss for just a few moments enforcement and compliance and penalties with regard to HIPAA disclosures. There is an agency under the United States Department of Health and Human Services that is responsible for enforcement, and that agency is the Office of Civil Rights, OCR, the Office of Civil Rights, under the Department of Health and Human Services. They are the ones that receive the complaints. They are the ones that do the investigations. They are the ones that would levy fines. They are the ones also that give information about this enormous law and how it applies to us if we have questions or need advice of any kind. The Office of Civil Rights. There are penalties. They can be civil penalties of $100 per person per violation, up to $25,000. There can be criminal penalties of $50,000, up to 1 year imprisonment for a wrongful disclosure of protected health information. If you have the intent to sell, transfer, or use protected patient information for gain, you can be fined $250,000 and serve up to 10 years imprisonment. Very steep penalties, very, very important for all of us to be responsible. The privacy complaints themselves, as I said, go to the Office of Civil Rights. Their number in New York City is area code 212-264-3313. This department can receive complaints directly from our patients. They're not required to go to us first. Certainly encourage a patient to contact me as the privacy officer, or certainly talk to you if they have issues of privacy. But they can be and should be encouraged to contact the Office of Civil Rights directly if they have a complaint. We can't discourage them from that. It is their right as a patient. Now, this concludes our training. It has been very fast and very brief, but hopefully complete. If you have a need to rewind and listen to any of this, feel free to do so. And I would ask that you fill out your quiz as quickly as you can, return it to the clinic office to my attention as soon as possible so we can give you credit and a certificate in your record for your training. Thank you again for your attention, and I wish you the best. Feel free to contact me if you have any issues concerning HIPAA.